And so the Supreme Court, the conservative majority ruled 6-3, holding that Harvard and UNC did in fact use discriminatory practices.
Welcome to Reporter's Notebook, where we talk to the Washington Examiner's top journalists about the stories breaking on their beats. I'm Jim Antle. I'm joined today by Supreme Court reporter Kaelan Deese. Kaelan, there's been a big Supreme Court decision about affirmative action. Got a lot of people up in arms. What did the Supreme Court decide?
So we're looking at a case against two universities, University of Harvard, University of North Carolina, and we're looking at private and public schools in both of these. But the decision was essentially the same in this case that was brought for Students for Fair Admissions that was seeking to challenge these schools. Harvard alleging that they were discriminating against Asian Americans in the admissions process, and in the UNC case, alleging that they were discriminating against white and Asian admission applicants. And so the Supreme Court, the conservative majority ruled 6-3, holding that Harvard and UNC did in fact use discriminatory practices. And it was quite interesting, I think, in part because I think that we're seeing a decision that was written by Chief Justice John Roberts, and it's sort of different than the majority decision that we saw last year in the overturning of Roe versus Wade, whenever Roberts was not completely on the same side as Alito.
Right.
And so that's interesting to me in part because we're seeing Roberts saying that these admissions practices at Harvard and UNC did not even fit the tests that were established beforehand in all of the Supreme Court questions about affirmative action in years past. So this was really egregious in the eyes of Roberts, and we're seeing today that the ramifications will be long-lasting in this decision.
So the initial take that a lot of people have is this will in fact seriously curtail the use of race-conscious affirmative action in college admissions?
Yeah, I think that is essentially what people are sort of focusing on. I think that for a long time we've been seeing universities that have been sort of preparing for this type of ruling. A lot of people knew that this was sort of on the agenda for the court. And I think that right away people are asking how are universities that tout DEI and diversity going to move forward. And I think that is kind of, in simple terms, exactly what they're going to do. They're going to continue to tout these types of things like diversity as things that they value, but in actuality, when it comes to the admissions, there's no sort of points here. Obviously, in 2003, we saw that in the Michigan case, the Supreme Court held that these actual points that were kind of being awarded to minority students for having that on their applications was not constitutional. And then we've been seeing the Supreme Court slowly sort of peel back the layers of these broad affirmative action sort of allowances with since 1976 with the Bakke decision. So it's kind of been a long and slow road down this journey, but the Supreme Court is finally saying you can talk about your race, you can talk about it in your admissions letters, but these administrators, these officials at these schools, they can't look at that and be like, okay, this is something that we need to consider for the student, whoever it is. We're saying completely, keep race out of the equation.
So a lot of Democrats and a lot of liberals were upset by this particular Supreme Court decision, but there was another Supreme Court ruling that made many of them very happy. Talk a little bit about what that one is.
Yeah. So we saw just before this week, we saw this ruling in Moore versus Harper, which was a complete rejection by the majority, not just the conservative majority, but we had some liberals factoring into that 6-justice decision. Essentially, it was dismissing this idea of this independent state legislator doctrine or theory. And it basically, stated, some proponents said that, the Constitution's election clause, like the times, place, section where it was saying that state courts don't have any ability to challenge what the election rules state legislators are imposing. And that was essentially what some people on the Democratic end called a power grab by state legislators who were trying to get this up to the Supreme Court. These legislators wanted all of their laws that they were making to not go challenged in state courts. And so what the decision in Moore versus Harper actually did, it was very clear that federal election laws, those are issues that cannot be sort of adjusted or changed by state courts. We should make sure that federal courts are dealing with federal election laws. But when it comes to the actual individual laws that apply per state, we just can't have a situation where lawmakers are able to impose whatever kind of rules they want unchecked. You actually have to have some checks and balances with the state Supreme Court, which is what happened in Moore versus Harper. We had halfway through this litigation at the Supreme Court, the U.S. Supreme Court, we had a change of the actual makeup down at the North Carolina Supreme Court. It went from a Democratic majority to a conservative majority, and they actually reversed the decision that brought this all the way up to the Supreme Court. So essentially, we now have a conservative majority in North Carolina, and they have done what the lawmakers originally wanted them to do with the gerrymandered maps. So it was kind of this moot point almost that Thomas was raising in his objection to the majority. It's kind of funny because also the Biden administration thought that this lawsuit was moot, albeit I think Thomas and Biden agree on that for different reasons. But yeah, I mean, a lot of people were wondering, were we even going to get something in this Moore versus Harper decision?
So there's a lot of attention always on the decisions that really break down along ideological lines or on conservative versus liberal bloc lines. But that really wasn't necessarily as prevalent this term as it has been in the recent past. Is that the case?
Yeah, that was something that we really kind of started to hone in on earlier this week and late last week. Is we wanted to not get ahead of the game, but also take in the math into consideration and the number of cases that were left. With just 10 cases left at the start of this week, we started to notice that there's actually no way that the Supreme Court can match the same number, that 13 number of 6 justices in the majority, 3 in the minority, split along their, the president, the party that appointed them. We're actually seeing just in 2 cases this year that 6-3 split, and it was in both criminal cases. And so 2 versus 13, I mean, some people are starting to, ask, like, what's happening to this conservative court? Mm-hmm. And I think that the question is somewhere in the middle. It's not that this court is growing, less conservative or more liberal, but it's that we're actually seeing the court start to sort of, shape into itself. It's starting to sort of understand that, just dissenting all the time as a liberal justice is kind of a futile effort. I've spoken to experts like Adam Feldman at Empirical SCOTUS who have, spoken to me at length, essentially saying that now we're seeing the justices, realize that, they could either just kind of be in the dissent time and time again, or they could actually have an effort, in these majority decisions to sort of change them in the way that they may not, obviously get the answer that they ultimately wanted, but at least they can have a part in shaping what this decision ultimately is. And I think that that's kind of, very interesting. I think Ruth Bader Ginsburg, for example, she was always, saying that she didn't like being in the dissent, even though she was, most known for being in the dissent. So obviously in these cases like affirmative action, like we saw today, a very fiery sort of exchange between Clarence Thomas and Justice Ketanji Brown Jackson, that will still be prevalent in these cases that we're seeing where, people, their partisan, edge is kind of, tweaking in that direction. But I think that in some of these other cases, we're looking at, some form of, unity, in to some regard. So I don't know. Well,
the Kumbaya Court.
The Kumbaya Court, for sure. And I want to stress that, each term is very different. We saw a fewer number of cases taken up this term. I believe it's 59 total decisions. So that's very small compared to other terms of past. So we don't want to start, reading the tea leaves too deeply, but it is certainly an interesting phenomena.
Wouldn't dream of it. Thank you, Kaelan. You can read Kaelan and the rest of our policy team's coverage at washingtonexaminer.com.